You are now live.
Good morning, everyone, and welcome to the COVID-19 Access to Justice Task Force. Excuse me. This is our last meeting before we issue our final recommendations. And the last few weeks have been particularly trying for our nation, and they come at the end of an exceptionally challenging year. On behalf of our partners, the Maryland Access to Justice Commission and the Maryland State Bar Association, I want to commend you again for your continued engagement and commitment to ensuring access to the civil legal justice for Marylanders, and your commitment to mitigating racial and other structural inequities that have exacerbated the pandemic. Over the past 5 months, we've developed a number of short and long-term reforms to protect against unnecessary evictions and foreclosures, to expand access to public benefits, to health insurance, to ensure safe workplaces, facilitate health and life planning, and to protect our most vulnerable populations from abuse and neglect. And we have come up with strategies for more effectively funding civil legal service providers, and for engaging and educating our community members. In a few minutes, Judge Davis will walk us through our third and final list of proposed recommendations, this time focused solely on the recommendations you haven't yet seen, and ask us to consider, among other things, ways to incentivize pro bono work and to address the recent challenges that litigants have faced in navigating the court system. I want to thank our co-chairs for the committees, for their teams, for making a final push to ensure that we have a comprehensive and impactful list of reforms for consideration today. I also want to thank Mark Skirty, president of the Maryland State Bar Association, who is a member of the task force and also a judge of the Maryland District Court, and to Ward Coe, who is the chair of the Access to Justice Commission, that is our partner in this endeavor. This is going to be our last opportunity to discuss the proposed recommendations together, and we've dedicated most of our meeting to that purpose. Before we get there, however, there's one short-term proposal that we've been asked to consider. Each of you should have received an email with the draft letter to the governor regarding civil legal aid funding. I want to thank our Civil Legal Aid Funding Committee co-chairs, Susan Ehrlichman and Catherine Bledsoe, for their work on the letter. And as a follow-up to our letter urging the governor to direct CARES Act funding to the civil legal justice issues, this letter requests that the governor take a more active and sustainable approach to addressing the chronic structural funding deficits faced by the Maryland Legal Services Corporation and other organizations within the civil legal aid community who provide critical support services but are ineligible for MLSC funding. Specifically, we're asking that the governor consider dedicating a line item budget appropriation in the amount of $20 million to MLSC and $2 million to non-MLSC funded organizations. And, you know, this amount is a sharp increase in, it reflects the sharp increase in the demand that the legal aid, legal services entities throughout the state have faced as a result of COVID-19. We expect that to persist at least throughout the next year. and there will be continued fluctuation in traditional legal aid funding sources, like interest on lawyers' trust accounts and court filing fees. We have recommendations that will address long-term funding issues, but they have to be approved and passed by the General Assembly before we get there. So recognizing that the current fiscal crisis may make it impossible for the state to meet the full amount of the expected demand for civil legal services, the letter requests an opportunity to meet with the administration to negotiate an amount that will support long-term sustainability of our civil legal aid community and improve low-income Marylanders' access to civil justice. Because the governor is currently preparing his budget for submission to the General Assembly in January, it's critical that this request be made prior to the final report. Thus, subject to your approval, the letter will go out on behalf of the task force in the next few days, and we'll talk about the letter itself in a second. But before we do that, I did want to make note of a couple of suggested changes that we've already received. The first pertains to MLSC's eligibility criteria, which is incorrectly defined in the letter as being limited to Marylanders with incomes below the poverty level. That language will be replaced with incomes below 50% of the Maryland median income. And that is consistent with MLSC's statutory authority. And I want to thank Susan Ehrlichman for pointing out that particular problem to us. The second suggestion comes from Robin Murphy of Disability Rights Maryland, who appropriately points out, in my view, that the communities disproportionately impacted by the pandemic include people with disabilities. Robin, we appreciate your feedback. And unless folks object, we will make that change as well. So first, if anyone has any objections to those two changes or comments about those two changes, would you let us hear from you now? And while folks are thinking about that, we should also, I guess, open the floor to any other suggestions or comments or thoughts. Does anyone have anything they'd like to add about the proposed letter to go out? All right, well, hearing no discussion, does anybody object to the letter going out? Okay, we will send the letter. Appreciate very much the consideration you all have given to that and for the feedback we've received. Now, I think we are ready to walk through the recommendations. I'm going to turn it over to Judge Andre Davis, and he's going to give us a summary of the recommendations and take comments. Judge Davis, take it away.
Thank you, Mr. Attorney General. Good morning, everyone. How ironic it is it not, that today, our last meeting of the entire task force, is a day when we're back to the future. Courts are closing, hospitals are filling up, and the dire situation that faces all of us in Maryland and around the country seems to get more dire every day. And I think this is a testament to the Attorney General foresight, coupled with that of Maryland State Bar Association and Access to Justice Commission and the courts of Maryland and all of you to try to get out in front of what has turned out to be a a crisis every bit as bad as in our darkest days back in the spring, we were afraid it could become. So we just have to put our shoulders to the wheel, as we have been doing, and continue to fight the good fight to make sure that substantial justice remains available to our most at risk citizens, brothers and sisters. So I'm happy to go through these recommendations which you received yesterday. A lot of people did so much hard work, massaging and investigating and offering insights and thoughts into what you have before you. It's just a remarkable collection of real effort on the part of so many people. And we are all so grateful for your inputs. So we start with where the Attorney General just left off, which is civil legal aid funding. That's really the key to so much, not everything, but so much of what is necessary to help us through this crisis. And the legal aid providers are on the forefront, of course, providing direct services so desperately needed, but the background funding mechanisms are desperately in need of enhancement. And so as you can see, what we've set forth in the number one recommendation under civil legal aid funding is an expansion of an intensification, if you will, of the funding streams and the infrastructure for funding of civil legal services in Maryland as a necessary prerequisite to any hope for achievement of providing access to justice to our citizens. So the recommendation is that we increase the distribution from the Abandoned Property Fund, as well as an increase in court filing fees to provide sources of funding for Maryland legal aid providers. Number two, that as the Attorney General just alluded to, the state's general fund be tapped for specific funding for civil legal aid services, and that all of us together, the bar, individual members of the task force, elected officials, and others join together in seeking an increase from the many financial institutions that provide IOLTA funding, that's interest on lawyers' trust accounts, which is one of the funding streams for Maryland legal services. And ultimately, do everything we can and have commitment from all stakeholders, elected officials, thought leaders, to ensure full funding for Legal Services Corporation. I don't think any of this is particularly controversial, but I want to open the floor to any comments that any one of you may have or observations on the critical need described in this tranche of recommendations. Okay, I don't think there's any doubt that the need is great and that these ideas are quite justified to go forward with in seeking what is so desperately needed. The next area is consumer protection. That was, like all of the committees, a very hardworking committee. And the focus here is on, I had a great conversation with Marceline White the other day, and I'm excited to join her in some of the work that she's doing in my individual capacity. But part of what we want to do as a result, overall, and particularly in the context of this pandemic, is we want to make people not need lawyers. Of course, that's an aspiration that is easier said than done. But to the extent that service providers can provide education, training, connections to resources so that people are actually empowered to protect their interests, to seek support on their own or with limited assistance from non-lawyer providers of assistance. That's very much something we want to try to achieve as a part of this work. And so that sort of encapsulates the idea set forth in this second level of recommendations. The California bill, Senate Bill 455, that's mentioned in this recommendation is a really remarkable piece of legislation that we would do well to have in Maryland, which is a specific appropriation for what's called education and empowerment processes along the lines that I just mentioned to arm citizens with limited resources on how to go about protecting themselves, seeking benefits to which they are entitled, financial management. And so what the California legislature and later the governor did was to sign this bill. It sunsets in 2025, but there's a $4 or $5 million appropriation to be distributed by way of grants up to $100,000 to organizations that provide this kind of education and economic empowerment. So the focus here is on what's called the unbanked or the underbanked and other at-risk families who may, with help from someone other than a lawyer, but acting on behalf of an organization that provides important support to these at-risk families, can stand up on their own in ways that protect their interests. But again, as with so much else, really state financial support in the form of general fund support is absolutely essential to achieve this. So we think this is something very important to come out of this task force and go to Annapolis and see if we can achieve maybe not $5 million, but really some funding to provide support to these, what you might call quasi-legal organizations that are providing the kind of support, as I say, that may make it necessary for at-risk families to avoid the necessity for legal representation in the first place. Any questions or observations anyone wish to offer regarding the recommendations regarding consumer protection? Okay, terrific. The next series of recommendations come from the Data and Legal Technology Committee. And I want to take my hat off to Franklin Baker from the 211 Maryland process at United Way, as well as to the courts who have engaged with us. The judges have engaged with us over how we can brainstorm ways to better improve access to court proceedings and the resources that are necessary to have that access. The sad truth is, as we all know, there are any number of people who simply don't have the bandwidth, literally and figuratively, to take full advantage of what the court offers by way of remote hearings, presentation of evidence, and that kind of thing. And so we've listed here some very specific recommendations. A couple of them already really in play, but we're looking for enhancements to making it possible for people with a little more guidance from the courts and from legal services providers to access remote hearings. We're recommending that a task force be formed to uplift, if you will, the court's availability to at-risk persons who have limited technology available to them, and to make it possible for lawyers to have better access to court documents when they undertake representation of persons at risk. We are hopeful that the MDEC process, and we're confident that the MDEC process, whereby the Maryland courts are going digital, will come to a conclusion sooner rather than later, and that that process, together with some of these other specific recommendations for providing notice to particularly pro se litigants, to make sure that pro se litigants have the access, receive adequate notice more than once, if you will, and to make sure that pro se litigants have the wherewithal to represent themselves fairly and equitably before the courts. And we know that the court in Maryland, all of the courts in Maryland, are absolutely dedicated to this goal. Again, the courts are closing, and these recommendations could not be more timely and of greater urgency today. It's going to be a real challenge for many, many months, for litigants in the district court and in the circuit courts around the state and in Baltimore, to ensure that they are treated fairly and equitably. Judge Cox was really illuminating the other day. Many of us, I think, were fully aware of this, but it was interesting hearing her say it out loud. What's happened in the courts in the last 6 months is not that people have been showing up or showing up virtually for hearings, that because the judges can't get through the whole docket, cases have had to have been postponed. What's in fact happened, wisely, of course, is that cases simply haven't been scheduled. And so the backlog of proceedings in all kinds of cases in the district and circuit courts is a growing backlog, and cases are not even going to be scheduled for what are likely to be remote hearings, because at this point, we just don't know when in-person proceedings are going to ramp up to a level that they can really happen. I hate to sound so dire, but this is where we are today. And so it's going to be important going forward, quite likely for a whole year, frankly, if not more, that people are going to need access to remote hearings and remote proceedings in very important kinds of cases. And so the technology infrastructure and the notice provisions and assistance to pro se litigants and lawyers representing those litigants, to say nothing of the normal run of cases, will need to be really the focus of a lot of attention. So I'll pause and see if there are any comments or insights with regard to these recommendations. Okay. The next collection of recommendations are the economic and food security recommendations, of which there are 6 plus one really special one at the very end, which is mentioned in the justifications. And by the way, I think the explanations and justifications that you see included in this six-page document are really cogent, to the point, but they will be expanded upon in our final report, to be sure. But I think what's set forth as justification and explanation for these particular recommendations really capture the essence of what is desired here. But you'll see that there's a recommendation that in an unemployment insurance application process, a simple checkbox be provided that can be used to trigger an application for health insurance for the person seeking those benefits. That seems to me a very low cost, no cost really, enhancement to the ability of the state to provide access to the needs of citizens who are in financial difficulty. Other than that, there are specific recommendations, as you can see, numbered 1 through 6, calling for the formation of a task force and increased Medicaid services, making permanent the reimbursements for telehealth. It's difficult to imagine that, frankly, the state would go back and rescind the important telehealth improvements that have been made so that providers can continue to provide the treatments that are so desperately needed for people living under very dire circumstances. I suspect many of you, such as like myself, were very moved the other day at the governor's press conference when the doctor kind of lost it emotionally, talking about his acquaintance who suffered from sort of the ultimate injury, if you will, in a sense, from the pandemic, just the depression that people are feeling and the stresses that are entering people's lives these days at all income levels, at all achievement levels. And so the need for telehealth, behavioral health treatments could not be more urgent. And I think we need to get behind the effort, and we will get behind the effort to ensure that providers can get reimbursements, including here, as you see as among the recommendations, telephone treatments. Now, that's not something that every provider, certainly behavioral health providers, will want to take advantage of, but many will. And many believe that particular clients can be served through telephonic consultations, and some don't. And so we need to make sure, I think, that every option, every tool in the toolbook is available to providers so that the people who need the help have access to the help. And of course, this is very much a part of access to justice, because without sound health services, then lives can spiral, if not out of control, can spiral in a way that makes it impossible for one to stay out of court and to keep one's family healthy and so forth. So are there any comments with regard to the economic and food security recommendations?
Judge Davis.
Yes.
This is Franklin. Just wanted to see if there's a way for either you or one of the co-chairs for this particular committee to just provide a little more color. I know you're going to offer more substantive color in the follow-up report, but just for the purposes of understanding, when you say providing services, health services for under-resourced communities at number 6, maybe just provide briefly for the group what's thought about, or what are you thinking that might entail? Maybe we're not there yet. We're just identifying there's a need for services, but if there is some additional color, that would be helpful.
Great question. I'm going to invite one of the co-chairs to elaborate.
Yeah, this is Paul Cucuzzola. What that gets at is it builds on a program that was in place, at least the recommendation does, a few years back, where the Department of Health created health enterprise zones, which is if you sort of think about current enterprise zones, it's a way to target resources, grant funding, tax incentives, loans, loan repayments into communities that are underserved in order to entice providers to serve those communities.
Any follow-up, Franklin?
Not only for this particular line item, but maybe some others. There may be some value in the follow-up piece, not just to specific technicians, who may be in the healthcare field or the specific field, technology, whichever recommendation category, but it may be some value in consulting as a follow-up to this task force, some people who might be able to provide additional expertise or resource to the extent that they're willing, interested, beyond the work of this task force. I think there is some value in leveraging, right, all the meaningful dialogues we've had as a group and the interconnectedness that's happened. And yes, we could certainly, like Paul, you could certainly pursue others who are part of your extended network for feedback and commentary and advice. But I do think there's a great opportunity that we'd be missing if somehow we were not able to tap the folks that are part of this broader task force to help with some of the execution, right, and further sort of elaboration on what's needed. And this one, to me, is close to my heart because I've been involved in work like this for years, but there are so many others where that might apply. So.
Yeah, we have members on our Medicaid subcommittee that are either themselves or in organizations that are sort of working a lot of these issues, whether it be from the program perspective or from perhaps the legislative perspective. There are people. This group in particular, this Medicaid group, had a lot of heft in it and did a lot of really good work and research, and the backup to these recommendations is pretty impressive.
Thank you for surfacing those comments, Franklin, and thank you, Paul. Anybody else? Okay, next is housing security, and as you can see, we have two fairly succinct and I think very important recommendations that we want to go forward on. Maryland is a true outlier when it comes to summary ejectment process. When Judge Bell was presiding over rent court in Baltimore City at Fayette and Gay 45 years ago, and when I was presiding over rent court at North and Harford Road 35 years ago, not much had changed in that decade. And frankly, not much has changed in the 35 years since I last served in summary ejectment court. Maryland is an outlier in the sense that it provides these collection services to landlords below cost. We have, for many decades, owing to just historical practice, had this system in place where tenants could be hauled off to court in about a week, and the coercive pressures of the state were brought to bear to extract payment from them to very often private parties, the landlords. People want to pay their rent, but sometimes people can't, or people can't pay it exactly on time. I remember when I was in rent court, we'd have a docket of thousands of cases, and on a bad day, maybe fewer than 200 people would show up for actual adjudications. And the reason for that was people paid their rent. Now, they paid it late sometimes, and when they paid it late, they were charged with additional fees, including court costs and that kind of thing. So what these recommendations are focused on is undertaking to get the state out of the low-cost business of debt collection. Obviously, we will always have a system, a judicial system, for property owners, landlords to seek redress in appropriate circumstances. But frankly, the pandemic, frankly, gives us an opportunity to make a change to Maryland law that is long overdue, in the opinion of many of us. Now, the idea here is to increase the fees, the filing fees, to provide a disincentive to the profligate filing, repeated filing of cases against tenants when alternatives to filing an action in court are readily available. And when, as I say, the cases aren't going to be heard in court anyway. And so the proposal here is to increase these fees, to provide a disincentive from constant, repeated, profligate, promiscuous filing of rent court cases, and to protect the tenant from any pass-through, to the extent necessary and appropriate, from any pass-through of these increased fees, with the idea that people will work these issues out with the help often of social services agencies and others. There is a concern, a quite legitimate concern, I suppose, for the so-called small landlord. And there can be carve-outs and other exceptions of provisions to protect the quote-unquote small landlord from any onerous burden in filing their cases in court. But I got to tell you, again, this is 35 years ago, when I was sitting there in rent court, the clerk would spend considerable amount of time stamping with my signature stamp, stamping documents where people never showed up in court, because again, it wasn't necessary for the matter to be in court for the rent to be paid. So we think that this is an important initiative. We think it's a timely initiative. We had a great discussion with members of the advocacy community who've been working on these issues for many years. And there will be, we understand, a number of proposals, again, before the legislature going forward in January, of which we hope this will be one. We don't see any inconsistency in the efforts to address this real problem of Maryland judicial procedure. I don't know if the Attorney General wants to mention his particular interest in this topic now, or you'll wait, Brian?
Well, sure. Thank you, Andre. Yeah, this is of particular interest to me, just because the state essentially subsidizes these nuisance filings. There are landlords, and we're in court with one of them right now, or we're in an administrative proceeding with one of them right now, who, as a matter of routine, file for eviction on the 6th of the month. If the tenant hasn't paid on the 5th, they're in court on the 6th. It happens even if they have a tenant who every month pays on the 10th. Folks don't get their paychecks on the 1st of the month all the time. Some of them get them later in the month, and they wait for their paycheck in order to have the money to pay the rent. So when we charge $15 for a landlord to file a summary ejectment action. And we are at the bottom of the pack nationally. There are only 2 states with lower fees for summary ejectment action than Maryland. The average is $120. So it seems to me that first of all, we ought to put a reasonable fee on these actions, least cover the costs for the court. They're hard to determine, but we shouldn't be subsidizing it. There will be additional revenue generated. there will be fewer cases filed, but still more money coming in. The additional money that comes in can be devoted to funding MLSC. And we can avoid probably hundreds of thousands of evictions in this matter of cases in this matter. The cases just drive up the costs for the tenants. The landlords are using the courts as just a collection mechanism. They're not really trying to throw people out. I think Susan Ehrlichman said to me that there are about 600,000 cases filed annually, and there are about 6,500 that actually go to eviction. And the fact that there are so few that ultimately result in families being put out on the street suggests that we're just adding costs, burden to the tenants, burden to the state, and it could be done in a much fairer, much simpler way. And we expect it'll generate millions and millions more dollars for the state, which is appropriate. And we think we can help with legal services to boot. So it's I think a useful mechanism across the board.
Thank you, Brian. Any comments or observations concerning this initiative? Okay, great. I hope I get to testify on this issue, because it's frankly something that I've thought about for a long time.
Hope we can do it together. Let's do
Yeah.
that.
The Pro Bono and Reduced Fee Legal Services Committee has just been fantastic. And as you can see in their recommendations, which are next, really just a comprehensive rethinking to build on the incredible initiatives of then Chief Judge Bell and Chief Judge Barbera to really infuse in the DNA of Maryland lawyers the idea that you have an obligation as a member of the bar to provide service, not just to your paying clients, but to the broader community, and particularly to provide services on a pro bono or limited bono basis. And these are just fantastic recommendations that are not going to cost really much money in terms of state funds, but through a partnership of the bar associations and leadership in government offices and otherwise, we really have an opportunity now to tap into, as I say, the goodwill of the bar, the big firms, the government offices, to push lawyers to take seriously their professional and frankly moral obligations to provide legal services. I am particularly interested in the recommendation that government lawyers really be encouraged to provide pro bono services, and I'm including in that Mr. Paul DeWolf, your lawyers in the public defender's office. There is, in my view, my humble view, there is no reason a government lawyer, a lawyer paid for her work by a government agency, whether it's a public defender or agency counsel or attorney general, not to engage in significant pro bono services. When I was city solicitor, one of the issues, of course, in this regard is always malpractice insurance, which is a serious matter. The agencies like Maryland Volunteer Lawyers and others who facilitate the provision of pro bono services to lawyers provide that kind of coverage. But my view as city solicitor was, if you're an assistant city solicitor and you undertake pro bono representation, the city, the self-insurer, Mayor and City Council of Baltimore, will provide coverage to you in your capacity as a pro bono, a provider of pro bono services. I don't think that's frankly very controversial. I just don't. Obviously, adequate supervision would need to be ensured, and that's true however and whenever the services are provided. But really, this is a great call to action by this task force to the bar writ large, that we all must roll up our sleeves, and until we get to that day when constitutionally or statutorily, and even after that day, that right to counsel in civil cases, in the important civil cases of which we are all aware, until we get to that day, we really need to ramp up the urgency among the bar to step up and provide these services to ensure the delivery of equal justice to all of the members of our community. It was Justice Brennan who said, among others, but he said it very poignantly, the equal treatment of those dissimilarly situated is every bit a violation of the equal protection imperative as is the disparate treatment of those who are similarly situated. And so the bar needs to embrace, as it does, and we need to embrace more warmly. And I think that these recommendations for the Pro Bono Committee lay the groundwork and provide a pathway to how we in Maryland can step up our game and ensure the delivery of adequate legal services to at-risk families and individuals who, through no fault of their own, are at a disadvantage in the absence of counsel in so many legal actions. So I'll open it up for any comments or observations. I'll step off my soapbox for a moment.
Judge Davis, this is Paul DeWolf. We agree that public defenders should and can do pro bono work. We allow it. And I'll be sure to get the word out.
Wonderful. Thank you so much, Paul.
That it's needed.
Thank you so very much. Anyone else? Okay. Finally, we have recommendations from.
My comment is thank you. Thank you to that committee. I know Guy Flynn is involved in that committee, and he's a member of our board, and I know we will follow the leader.
Thank you. Thank you very much, Guy and Wilhelm. Yeah.
And Judge Davis, I just had 2 points, if I could.
Yes, of course, Robin.
One, thank you. One is on the first section here. There's, I just want to point out an observation that talks about directing attorneys towards the most high priority cases, and that can mean many different things to different people depending on what's a high priority case. So I just ask that people be mindful of that, and also that it not have pro bono attorneys directed from existing relationships that they have with providers where they provide specialized services to the community and siphoned into this, that it's just an additional amount of attorneys, not to take away from our existing relationships. And then in a similar vein on section the little I3, the same point that attorneys not donate or engage in pro bono services, not be directed away from the agencies that they already have existing relationships with and they already donate to, because we get a number of donations when the bar fee, and I'm sure other agencies do too, when the fees are due. And I think that's recognizing the agencies, and I wouldn't want to see that diverted from all the existing organizations.
Great point. Great point.
I think the caveat there is that you have several existing pro bono organizations, and like Legal Aid, we have our own capacity within Legal Aid. I'm reading this, my interpretation is a general encouragement through various means to private lawyers to increase their pro bono activities. I'm not reading this to say that we want to create another organization or another mechanism to try to interact with all the existing pro bono activities, because that might sound okay, but that could be a little more redundant. So am I reading it correctly? Are we encouraging lawyers through various means, or are we talking about setting up another mechanism to work with the existing mechanisms?
Yeah, generally speaking, this is not a cannibalization effort. We are not cannibals, but we are rather going to, I think the word used was additive. We're looking to add on and to work with the existing infrastructure, not recreate the wheel, but really make sure that we're using the weight of this task force and these recommendations to raise this pro bono army among all of these various sectors that we've identified, and to work with the existing infrastructure and within the existing infrastructure, but more as a convener of best practices and ideas, as you have seen within these recommendations.
That
Great.
would be helpful.
Great point.
Encouragement, that will be helpful.
Yep.
Great point. And
Thank you.
an exemplar of that is the mention of justicereferrals.org. I mean, it would be great if we can really raise the profile of that platform, because my guess is large numbers of Maryland lawyers simply haven't been introduced to it. And so that's the kind of thing, as Guy says, an additive approach to making sure that lawyers know about their obligation, all of them do, and are encouraged and nurtured to continue to satisfy those obligations, both through service and, Robin, you're absolutely right, through giving. Anybody else? Okay, great. I mean, as a profession, it's our responsibility to solve these problems. It's our responsibility. It's the responsibility of the bar. And then finally, surviving abuse, neglect, and exploitation recommendations focused here on vulnerable adult populations and those who serve them, and to make sure that they continue to have the protection to which they are entitled legally and morally, and that they don't get lost in the hubbub and chaos of a public emergency such as what we're going through now. I will stop there, Rena and Mr. Attorney General, and just want to call attention to a comment in the chat that elaborated a little bit on the Attorney General's comments about the evictions. But thank you all for your attention and for the hard work that you've put into the work of the task force, and for your participation today. That's all I have.
Well, Judge Davis, thanks a million. Your help in overseeing all these issues has been enormously beneficial. And I guess at this point, we should talk about whether anybody has objections to the recommendations, whether there are further comments about them before we seek their final approval. Does anyone have any thoughts, comments, questions? Okay, hearing none, hearing no objections, we'll deem them approved. And we will memorialize this excellent work. We have a report writer, Tom Waldron, who is going to have a draft report to you for your review and feedback by mid-December. Our objective from the beginning was to get this all done so that we could put it on the table in time for the General Assembly to consider the different suggestions when session commences in January. We're on target, we're on track, and we hope to have it ready. Once we've issued the final recommendations, we would ask all of you to use your platforms to amplify the proposals and generate support for their implementation, enactment, or whatever. And though, this is our last scheduled meeting before the report is issued, we know there's much more work that needs to be done to ensure that Marylanders have full and meaningful access to justice. Our office will continue to work with the Access to Justice Commission in support of all of these efforts. We hope that you will join us as your schedule permits, particularly as we seek to advance the legislative recommendations when the General Assembly convenes. There'll be opportunities for you to provide written testimony, oral testimony, and more broadly elevate the issues and reforms that we've discussed. The committee hearings, as we understand it, will not be in person this year. I'm not sure how testimony will be limited, if it will at all, and it'll likely vary from committee to committee. But it does mean that people can provide testimony virtually, and we will try to let you know when hearings are occurring and seek your support and perhaps oral testimony if appropriate. The recent spike in COVID-19 positivity rates, hospitalizations, makes clear that the pandemic's threat to our financial and economic health is far from over, as Judge Davis said at the beginning of his remarks. We hope we can continue to leverage your collective experience and expertise as we monitor the impact of the virus on the civil legal system. This may include, for example, reconvening over the next several months to debrief on our successes, and if we have any failures, to talk about those and see how we can continue to move the ball on issues that didn't succeed in the first round of legislative consideration. But we'll also be reviewing the data on court filings and access. Once we have a better idea of when and how we want to connect, we'll be back in touch. I want to thank each of you for your time, your engagement on these issues, both on behalf of the task force and in other endeavors as well. Beyond the task force and congressional advisory committee members and committee co-chairs that you've seen on your screen every month, there are a number of other individuals who have contributed significantly to our work. There are over 100 committee members from a broad cross-section of different disciplines, private and public sector, attorneys, advocates, community organizers, several dozen attorney general employees, staff from divisions throughout our office, including our communications team. There have been a host of law students from the University of Baltimore and the University of Maryland law schools. Thank you very much, Dean Weish and Dean Tobin, for encouraging your students to participate. They've been a great help. And, you know, it takes an enormous effort to recruit, to organize, to engage such a sizable group of stakeholders. And I'm impressed with what we've accomplished in such a short time. I want to thank especially the vice chairs, Judge Davis and Rena Shaw, and our partners in the Access to Justice Commission, the Maryland State Bar Association. Your leadership has been critical to our progress. And to each and every person who is on this call, and to all members of the task force and the committees, I want to say, but for the hundreds and hundreds of hours that people have put in, and but for your thoughts, your expertise, and your hard work, we would not be where we are today. I think we're going to have a really excellent report, and I am hoping that we will meet with success in the General Assembly and in the different state departments, administrations, et cetera, when they consider our recommendations. I really can't thank you all enough. This brings us to the end of this session. And I hope that you have a beautiful day today, notwithstanding the precipitation. And I'm very proud of what we've accomplished in a relatively short period of time. Thanks for your great work. I look forward to seeing you soon.
Attorney General, hold on.
Yes.
You made a request to those of us gathered here. But before I respond to that request, I want to ditto all those thank yous that you have just expressed. I've been in this job for 25 years this year, and never before have I witnessed such a group working together and given the opportunity to participate. So I want to thank you, your leadership, and all the great minds and brains and efforts that came together. This is amazing. All the names you mentioned, and I hope we have some success in the outcomes of the legislature. Your request, or what you mentioned, was the opportunity to provide information, testimony to the legislature. I think you are aware, and a couple of the old school legislators, I know Senator Jill Carter knows that under the guidelines of the Legal Services Corporation at the federal group, their legal aid can provide testimony anytime, but we have to be requested to do so in writing. From time to time, that become cumbersome, not timely, and is a challenge when you have a new crop of legislators and they have no idea about the existing law. So we kind of expect others to help others and inform others. I don't know if Delegate Sandy Bartlett is aware of that. I don't know if Delegate Kippinger is aware of that, but we need a request in writing to testify on any bill anytime, and we are always willing to do so. So I want to say, put that caveat out there and let you know what the law is. I can't solicit that you send a letter, but I can tell you what the law is. So once you smart folks are educated of what the law is, you know what to do. So thank you again.
Yeah, thank you, Wilhelm. Good reminder to the legislators, call on Wilhelm. They will give you good information, good support. You know, as I'm looking at the folks who are on this screen, I realized that I forgot to thank the folks who did our town halls. We had a series of town halls that are up on the Access to Justice Commission's website, up on the Attorney General's website, but Guy Flynn and Paul Cucuzella and many other folks, in addition to their work on the task force, Zafar Shah was another one who appeared in several different of these town halls, devoted time in the evening to just guide people through the eviction process, through the end of life decisions that people are able to make and encouraged to make, and unemployment insurance. These forums were extraordinarily informative, I think valuable. And if you have folks who are interested in accessing those sessions, go to the Access to Justice Commission's website, or the Attorney General's website, and refer people to those forums. Anybody else? Yeah, Franklin.
Brian, thank you so much for being so complimentary to this team. I would just ask, if it's not too much trouble, some might find it helpful for a variety of reasons to get a personal note from you that essentially goes to the co-chairs of the various committees, essentially, thanking whatever words you want to use, but thanking them for their service, et cetera. If that could be arranged, I think some might find it very helpful, and a variety of rationales for that, but I'll just make that request.
We're on it, Franklin. We will have a citation and a letter to everybody. And as I say, I can't begin to thank you enough for the great work that you all have done. Any other final thoughts? Okay, folks. Thanks again. Let's get ready for the legislative session, and we'll see you all soon.
Thanks all. Bye, Rita.
Bye.
Bye, Tom.
Bye. See you later.
Bye. Bye, everybody.
Rita,
Bye, everyone. Bye, Wilhelm.
all right.